In one 5-minute stretch of testimony, a member of Congress named 3 separate incidents, one after another, without pausing. A fatal encounter with a mother of 3. A teacher shot multiple times. A nurse under investigation. When 3 serious claims get delivered back-to-back in a single breath, it's easy for all 3 to blur into one general impression. Today, we're doing the opposite, stopping on each one individually, checking what's actually confirmed, what's alleged, and what the hearing record itself does and doesn't establish. Then we're covering a separate, more technical thread, how federal background investigations actually get adjudicated and what that process does and doesn't guarantee. Quick context, timeline fast version. Throughout 2025 and into 2026, in the same broad set of DOJ and FBI oversight hearings we've covered across this series, several individual law enforcement incidents get referenced directly by name in the course of broader questioning about agency accountability and immigration enforcement operations. These incidents are distinct from each other, involve different agencies and different locations, and deserve to be evaluated separately rather than as one undifferentiated pattern. That's exactly what we're doing today. Here's what a fast-paced hearing exchange tends to compress that deserves to be unpacked slowly. In testimony, a member describes an incident in Minneapolis involving federal immigration enforcement agents and a woman described as a 37-year-old mother of 3. The claim, as stated in the hearing, that the FBI opened a criminal investigation into the incident and that the investigation was subsequently shut down. A separate connected claim in the same hearing set, that state and local law enforcement obtained a court order for access to the scene to preserve evidence, and that federal agents did not comply with that order, with the Department of Justice subsequently declining to collaborate with the state-level investigation. Here's what needs to be said with real precision. These are 2 distinct, serious claims. One about an investigation being closed, and one about non-compliance with a specific judicial order. Both are, in principle, independently verifiable. An investigation status can be confirmed through DOJ or FBI public statements, and compliance with a specific court order is a matter of that court's own docket. In the material available to us from the hearing testimony itself, both claims are asserted by the questioning member. We have not independently traced the specific Minnesota court filing referenced and would encourage anyone following this specific incident closely to check that court's docket directly, rather than rely on any single hearing characterization, including this one. What is separately confirmed, independent of either specific claim, multiple members across different hearings have raised broader concerns about DOJ cooperation, or lack of it, with state and local authorities in cases involving federal agents, meaning this incident, whatever its specific facts turn out to be, sits within a broader pattern of oversight questions that isn't unique to this one case. Thread 2. The Chicago shooting. A second incident, named separately in the same hearing, a shooting involving a Chicago area teacher. The claim, as stated, that a teacher was shot multiple times by a federal agent, with the agent reportedly making comments about the incident afterward that the questioning member characterizes as inappropriate. Again, precision matters. A shooting involving a federal agent and a named private citizen is, if it occurred as described, a serious use of force incident that would ordinarily be subject to independent review through the DOJ's own Office of Professional Responsibility, through Inspector General review, or through the ordinary criminal justice process if charges are considered. Whether such a review has been initiated and what its findings are is not established by the hearing statement itself. A single sentence in a congressional hearing describing an incident is the start of a fact-finding process, not the conclusion of one. We're not able to independently confirm the specific details characterized in this brief hearing reference, the agent's exact statements, the exact circumstances of the shooting, or its current investigative status from the transcript material available to us. This is exactly the kind of claim where the responsible next step for anyone following it is checking for local news coverage with named sourcing, any filed civil or criminal case connected to the incident, or any DOJ or Inspector General statement addressing it directly. Thread 3. The third case referenced. A third case named in quick succession in the same exchange, involving an individual described in testimony as a nurse, with a dispute over how that person has been publicly characterized by administration officials. The specific claim? That this individual has been described by senior officials using serious, specific labels, while the questioning member states DOJ has not shared evidence supporting those characterizations with state or local investigators. This is a case where a public dispute over characterization, not necessarily over the underlying facts of what happened, is the central issue being raised. Whether a specific label applied to someone by a government official is accurate, exaggerated, or premature is a genuinely different question from what actually occurred in the underlying incident. Both questions matter, but they require different kinds of evidence to resolve. The underlying facts require investigative and, if applicable, judicial findings. The characterization question is more directly checkable by comparing the specific public statements made against whatever evidence, if any, has been publicly released to support them. As of the material available to us, we have not identified a public release of evidence specifically supporting the stated characterizations, nor have we identified an independent finding refuting them. This remains, in the fairest reading, an open dispute. Why these three threads belong together and why they shouldn't be merged. Here's the analytical point worth pausing on before moving to the next thread entirely. All three of these cases were named back-to-back, in rapid succession, in the same breath, during the same hearing. That's an effective rhetorical technique. It builds a sense of pattern and urgency. It is not, on its own, evidence that the three cases share a common cause, a common level of severity, or even a comparable evidentiary basis. Treating three individually serious but individually unverified claims as one confirmed pattern is a distinct kind of error from disbelieving all three outright. The responsible approach, and the one we're taking here, is holding each one separately, taking each seriously enough to flag and track, without inflating any one of them into more certainty than the current public record actually supports. Thread 4. How background investigation adjudication actually works. Shifting now to a more technical, standalone thread. The process referenced across multiple hearings when officials are asked why certain unfavorable information about a nominee didn't appear to affect their confirmation. In testimony, Patel describes background investigations as being conducted by career professionals in a specific division, with adjudications made independently of his personal involvement. A structural separation between the fact-finding function and the decision-making function. Here's the part worth explaining clearly because it's genuinely useful background for understanding several threads across this entire series. A federal background investigation typically produces a report of findings, which is then separately adjudicated against a specific standard. Generally, whether the findings raise a security or suitability concern significant enough to affect the specific position in question. That adjudication standard is not, was anything negative ever said about this person, which would disqualify nearly everyone in public life. It's a more specific, threshold-based judgment about relevance and severity to the particular role. That structural explanation is a legitimate description of how the system is designed to work. It doesn't, on its own, confirm that the process functioned correctly in any specific case raised in these hearings, including the pyro-related claims discussed in earlier videos. What it does provide is the correct framework for evaluating those claims. The real question in any specific case isn't just, was negative information available, but did it meet the specific adjudication threshold for this specific role? A judgment call that reasonable career reviewers can differ on, and one that outside observers generally can't independently verify without access to the underlying report itself. The pivot. Okay, but look, we have to be completely objective here across all four threads. On the three named incidents, rapid back-to-back citations of serious cases in a hearing are a legitimate way to illustrate a broader concern, and raising them doesn't require the questioner to have personally completed an independent investigation into each one first. That's precisely what oversight hearings exist to trigger, not something they're expected to have already resolved before the hearing occurs. On the Minneapolis non-compliance claim specifically, alleged non-compliance with a court order during an active, evolving incident can sometimes reflect genuine operational or safety confusion in the moment, rather than deliberate defiance. Chaotic scenes involving multiple agencies don't always produce clean adherence to procedure, even without any bad intent. And that's a fair alternative explanation worth holding alongside the more serious reading. On the background adjudication process broadly, a threshold-based, career professional-run system is actually a reasonable, standard design specifically intended to prevent political appointees from either weaponizing or ignoring background information for political reasons. The structural separation Patel describes is, in principle, exactly the kind of safeguard reform-minded critics of past administrations have called for, regardless of how it's being applied in any specific case now being questioned. Use of force investigation specialists note that federal incidents involving injury or death are almost always subject to some form of independent review, internal, inspector general, or judicial, and that a hearing reference to an incident is typically an early public marker in a much longer process, not itself the resolution. Federal personnel security specialists discussing background adjudication standards specifically emphasize that the "does this rise to a relevant position-specific concern" threshold is a real established practice, not something invented to excuse any particular nomination, though they also note that public confidence in the process depends heavily on transparency about how specific adjudications were reached, which is often exactly the transparency oversight hearings are trying, and generally failing, to fully extract. Real talk. How this affects actual people. The three named cases matter because federal use of force incidents and enforcement operations affect real communities directly, regardless of the broader political dispute around them, and the standard being tested in each of them, independent investigation before conclusions are drawn, is the same standard that protects anyone, on any side of any dispute, from being tried in public opinion before the facts are established. The background adjudication thread matters because it's the exact process that determines who ends up in positions of significant authority over the rest of us. Understanding that it's threshold-based, not zero tolerance, helps you evaluate future confirmation disputes more accurately, regardless of which administration or which nominee is involved. I'll be tracking whichever of these three named cases produces an actual filed case, Inspector General finding, or named source reporting next. That's the point where any of them moves from raised in a hearing to independently confirmed. Subscribe for that update. Drop below. Which of the three cases named today do you think deserves the most independent follow-up reporting? Let's discuss it in the comments.